Good morning, everybody. My name is John Piggins. Welcome to the Miller Johnson webinar. With me today is Loic, Dimithe. Today we are going to talk about supplier, customer financial issues and possible bankruptcies for them, and what to do when you see that a supplier or customer has incurred financial issues or filed bankruptcy. Before we get into that, however, I'm going to turn it over to Loic to give you a quick COVID update. Loic?
Thank you, John, and good morning, everyone. Thank you for joining us. As we often kick off our webinars here, just wanted to give you a quick update on the state of play on COVID-19 on our world. So just some quick statistics. The global count of confirmed cases is currently sitting at 7,097,717, with 402 confirmed deaths. The U.S. count is currently sitting at 1,956,499 confirmed cases, with 110,932 confirmed deaths. And then finally, sitting here in Michigan, we have a confirmed case count of 58,999 and a confirmed death count of 5,673. Just some other highlights that we want to bring to your attention is as Michigan begins to reopen, restaurants, pools, libraries, and related services are slowly opening to varying degrees of capacity. The S&P 500 on Monday erased its losses for the year, surpassing its closing level for 2019. That's some good news about what's going on in the market. The WHO, World Health Organization, recently released additional information about how the COVID-19 virus spreads, indicating that it appears that people who exhibit no symptoms, the virus in those cases tends to rarely spread among individuals. So that's positive news in terms of the ability and our understanding of how COVID-19 spreads amongst our community. And with that, that's the COVID update, and I turn it back over to John to jump into our presentation for today. Thank you.
Thanks, Loic. Okay, so as I indicated at the top, this is going to be a discussion of what you should be looking for if a customer or supplier is experiencing financial difficulties or in fact files a bankruptcy proceeding. The first thing that we need to talk about is communication. I represent all parties involved in bankruptcy and creditor and debtor rights matters. So I'm regularly counseling not only creditors but debtors in these situations. And the biggest thing that a debtor can do for itself when it is experiencing financial difficulties is communicate with its constituencies, with the people with whom it does business, and lay out to them what its plans are and how it is addressing its financial issues. And do that up front, because the more communication, the better. And I recommend that also for creditors of customers or suppliers who may be experiencing financial difficulties. The more information you can get from them, the better. If they are hiding their head in the sand, so to speak, that is a huge red flag if they are not communicating with you and things are starting to get bad as far as collections are concerned, or the time between invoice and payment is getting longer and longer as time goes on. If they are not communicating with you as to why that's happening, that's a huge point of concern, and you should be thinking about some of the options that we're going to talk about today. So we need to look at the facts and circumstances in every case differently, because not each case is different, and there are some general rules, but it's better to talk to a professional and determine exactly what you should do in every case. So if you want to go to the next slide. So first we're going to talk about distressed customers. If you have customers that you believe are having financial distress or in fact have filed bankruptcy, there are a number of things you want to do. Obviously, if time is increasing between invoicing and payment, that's a sign that your customer is, experiencing financial difficulties. Or if they come to you and request extensions or other accommodations, again, if they come with that request, you want to get as much information from them as possible. Don't just take the request and say, hey, I'll consider it, or say yes or no. Ask them why. Ask them what their plans are. Get as much information as possible so that you can make an informed decision as to what you want to do. Be aware of preference treatment. I think that's important to know. It's not going to change. At the end of the day, I don't think it's going to change your action or reaction to your customer, but you should be aware of what we call preferences, and those are typically payments that you receive from a customer which are past due within 90 days of a bankruptcy filing for that customer. Those payments are typically payments that can be clawed back, as we say, by the bankrupt debtor or by a bankruptcy trustee. However, as I said, I don't think that changes the actions that you should take if your customer is in financial difficulty and contemplating bankruptcy. I always counsel my clients to take the money and worry about the preference clawback later, because it may never happen, and if it does happen, there are numerous defenses to a preference claim that can be asserted, and you may very well not have to pay all of it back, or you may not have to pay any of it back, even if you are, even if the demand comes for repayment. So go to the next slide. As I said, there are a number of defenses to preference treatment. Contemporaneous exchange protects payments made at or near the same time that the creditor provided equal value in goods or services. Ordinary course of business, this is a very prevalent defense that we use often. If the party's ordinary course of business and timing of the payments was similar to past dealings with that customer, you're going to have a defense to the preference. And of course, new value is also a large defense or typical defense that we employ, where if a customer pays you a significant amount of money and after they pay you that money, you supply them with more goods or services, then the value of those goods or services can be offset against the preference payment that they demand repayment of. Go on to the next slide. So the other thing you want to look at when a customer is experiencing financial difficulties is any contracts you may have with that customer. It's important to know what those contracts say and know what your rights under those contracts are, especially what remedies are available, what notices you have to give to the customer in order to, for instance, declare a default, and how long does the customer have to cure any defaults once you make that demand. Terminating the contract before the customer files for bankruptcy may be a very important aspect of your being able to deal with this customer much more easily once the bankruptcy is filed. So if you have a ongoing contract with the customer, you want to look at it very carefully and determine if you have the right to terminate the contract immediately. Obviously, there's a fine line there, because if you have a customer that is a regular customer, if you want to continue dealing with them in some form, because obviously you are making a profit on selling to them, you don't want to scare them away. On the other hand, you need to protect your rights if there's a significant AR out there that you need to protect. You need to look at all of your options. So that's the first thing, is if you have a contract, look at the terms, consult your attorney, determine what your options are and how quickly you have to act on them. Next slide. So some of the things you could consider if there is a contract. Change the credit limits. If the credit limits are a certain amount, you could cut them in half. You could reduce them by more. Consider acquiring COD or prepayment for all products or services going forward. Again, the contract, if there's a contract, has to allow that change. But if you can do that, or if you're simply working on an invoice-to-invoice situation where there is no written contract, you're allowed to do that at any time. The other thing you might consider is demanding a purchase money security interest on the goods sold. This requires you to jump through a number of hoops and may not be worth the trouble, but if it's a significant receivable and there is a lot of money involved and a lot of potential business going forward, you may want to consider this. I suggest you talk to an attorney before you do that, because there are certain notices that have to be given to the other secured creditors of the customer before you can actually have a purchase money security interest that trumps other secured creditors. So move on to the next slide. So the statutory rights. Goods in transit, you can consider exercising the right of stoppage of delivery. Again, there's a fine line here, because if you're working with a customer that you want to keep, stopping goods in delivery is not going to make them happy and maybe make them look for another supplier of their goods or services. So that's a fine line, and that's where I come back to communication. If you can get a hold of your contact at that customer first, tell them the concern that you're experiencing, get as much information as possible, and try to work through something before you do something that drastic. Reclamation rights. If the customer has received delivery of goods within the last 10 days, or if you've received a representation of the customer's insolvency within the last 3 months, you may have a right to reclaim the goods. In addition, if there's a bankruptcy filed, you're going to have a longer period of time to reclaim the goods. It's 45 days before the bankruptcy filing. But again, that's a remedy that you want to consider very carefully before you pull the trigger, because again, at that point, the relationship has probably broken down to the point where you may not get any more business from this customer if you take some of these actions. On the other hand, if the receivable is large and you do not intend to continue doing business with this customer, then these are options that you should seriously consider to protect your receivable. Move on. Next slide. Adequate assurance. You can certainly also demand guarantees, liens, security deposits, letters of credit. These are a little bit less troublesome as far as wanting to keep the business going with the customer. You can certainly go to the customer and say, listen, we don't feel comfortable continuing to deal with you under your circumstances. Maybe a principal of the company can give you a guarantee for whatever accounts receivable are out there and all future accounts receivable. Maybe you can take liens on other assets that the customer has, or get a security deposit or a letter of credit to secure repayment of monies that they may not be able to pay if their situation worsens. Statutory liens. These are very specific and in specific industries. You can see there: mechanics liens, tooling liens, artisans liens, landlords liens, or shippers liens. Those are liens that are provided by statute. You don't have to ask the customer for them. You may have to take certain actions in order to perfect them, but I would consult an attorney if you are in one of those categories and thinking about whether or not you can hit one of those liens against a customer that's in financial trouble. Next slide. So if a customer doesn't pay as required, you can consider refusing to supply further goods or services. Again, it's a fine line. Obviously, if it's a customer that you want to keep, that's not something that you probably want to do right out of the box. Changing payment terms if permitted. Again, if there's a contract that governs what those payment terms are, it's going to be more difficult to change the payment terms. But if you're dealing with them simply on an invoice basis, on a purchase order basis, it is fairly easy to change the terms. Again, communication. Communicate with them first. Let them know what you're thinking about doing and why, and try to get as much information as possible. And then terminating any contracts that you may have. Again, you have to look at the terms of the contracts. Typically, there are default provisions that allow you to terminate the contracts on certain notice, advance notice, and you may want to consider doing that. Again, consider the collection pressure that you give against maintaining the relationship you have with your customer. Once a bankruptcy is filed, the relationship with the customer is certainly going to change. The bankruptcy laws dictate what you can and can't do, and you're going to want to consider probably more stringent measures if a bankruptcy is filed. Go to the next slide. So once a bankruptcy is filed, obviously you want to try to find an attorney experienced in bankruptcy law immediately to determine what your options are. The biggest thing when a bankruptcy is filed that you need to be aware of is the automatic stay. Once a bankruptcy is filed, if that customer has filed bankruptcy there, the automatic stay prevents any party from taking any action in an attempt to collect any funds from that customer that the customer may owe. You can't send a demand letter. You can't file a lawsuit. If you've already filed a lawsuit, you can't continue with that lawsuit. The automatic stay is very broad, and as the name infers, it is automatic. You don't need a separate order from the court to bring the automatic stay into effect. It is there once the bankruptcy is filed. So you want to be very careful as to what you do so that you do not violate the automatic stay. On the other hand, if you are dealing with a customer who files bankruptcy and you're simply dealing with them on an invoice-to-invoice basis or a purchase order-to-purchase order basis, you can unilaterally change the terms of your dealings with them going forward so that all dealings with them going forward are in cash on delivery, or cash in advance, or you can stop shipping to them altogether after the bankruptcy. The one thing you can't do, however, is say, I'll continue to ship with you if you pay all of the debt that was due before you filed bankruptcy. You can't use it as a tool to collect that pre-bankruptcy debt because the automatic stay prevents you from doing that. So while you can protect yourself going forward with cash on delivery or cash in advance or just refusing to ship, you cannot use that to collect the pre-petition account receivable. We can move on to the next slide. The other thing you want to do is, if you have a contract, you want to take a look at whether or not the contract is considered executory. If there is a contract with the supplier who's filed bankruptcy, the automatic stay, again, precludes the termination of the contract. Before continuing to do business with the debtor, you should understand whether the debtor has authority to use cash from its lenders to pay for your goods. Typically, there is a separate agreement with a debtor's lenders which allow it to pay some but not all of its debts going forward. And there's a specific budget that is on file with the court as public record that will show typically what that debtor is allowed to pay in any certain circumstances. So before doing business, the other thing about the executory contracts is that the debtor has control of those. Typically what happens is the debtor can either assume that contract If the debtor assumes that contract, then the debtor does have to pay any pre-petition debt that it may owe to you, and then continue on with the contract. If the debtor rejects the contract, the debtor does not have to pay the pre-petition debt, but the contract is deemed canceled, and you do not have to deal with the debtor under that contract any longer. So that is going to be something that you're going to want to know as soon as possible. As I said, the debtor has the control there, but typically in a bankruptcy, a creditor can file a motion to require the debtor to take action on that contract, either assume it or reject it, so that you know what's going on moving forward. So you're going to want to consult a bankruptcy attorney to decide whether or not it makes sense for you to file such a motion and get some closure on whether or not that contract is going to go forward. Next slide. Make sure when a bankruptcy is filed that you take note of the various deadlines that are in any notices that you receive. If you're a creditor, you're going to receive notice of the bankruptcy. And there are also deadlines in the bankruptcy code. For instance, your claim may get priority treatment if it is for goods or services that were delivered to the debtor within 20 days before the bankruptcy was filed, and those goods and services were delivered in the ordinary course of business. But you need to make sure that that claim is filed promptly so that the court knows and the debtor knows you're claiming that amount as a priority claim as opposed to just a general unsecured creditor claim that does not get priority treatment. Even if you have just a general unsecured claim, though, you're going to want to take note of the deadline for filing claims and make sure you get a timely claim on file, no matter what the priority of your claim is. The other thing that you can seek in some bankruptcy cases is critical supplier status. We call it critical vendor status. Typically, this is a situation where if a vendor is so critical to the debtor's business that the debtor would fail unless you continue to supply them goods and services, and the debtor has no other source for those goods or services, you can be deemed a critical vendor. In that case, the debtor can get permission from the court to pay your pre-petition claim in full and move forward and continue to use you as a supplier. Again, this is a very narrow category, but it is something that you might consider if you are in a situation where you might be able to be considered a critical vendor to a specific company that has filed bankruptcy. Next slide. So we've talked about customers. Now we're going to talk about distressed suppliers, and I'm going to let Loic discuss that portion of this webinar with you. Thanks. Loic?
Thank you, John. Again, thanks everyone for joining us. First piece of advice we advise is, again, to reiterate the importance of communication. Having an open dialogue, both with your customers and suppliers, is essential to maximizing your outcome once you get through this entire process. And so the first thing we would encourage you to do with regards to any suppliers that are experiencing some level of financial distress is to communicate with them and try to understand what exactly is going on in their business that's causing them to experience the financial distress. And then from there, you really will have to determine how you want to react to the information you receive. And so you may ultimately determine that you want to support your supplier, that you have a good business relationship, and that, it's just a temporal situation that they will overcome, and that, that business relationship will be stronger moving forward. Examples of that may include just simply accelerating payments if they have a liquidity crisis or something else, assisting them in some other way to the extent that, based on your understanding of what's going on, you think you can help them get through their issue. As part of that communication, you want to understand their plans, how they intend on getting past whatever it is that's holding them up, whether they plan on continuing to supply goods and services, whether they plan on reorganizing, or whether they plan on simply liquidating and closing doors. And you can't obtain that information without having that open dialogue. So again, it's extremely important to communicate and be on open terms in that regards. You want to confirm that the supplier has what they need in order to be able to do what they plan on doing. So if they do plan on continuing to supply goods, you want to make sure that they have adequate raw materials, adequate staffing, and liquidity, and whatever else they need to continue their operations. Next slide, please. From there, we encourage you to kind of begin to evaluate your existing supply chain, evaluate your existing inventory and parts, products, raw materials, and other things that you have on hand, either at your own location or third-party locations. Determine how quickly, if there is an interruption in your supply chain, how quickly it'll be a big problem for you, whether you have existing reserves that allow you to get through a month, 2 months of supply chain disruption, or if it's going to have an immediate impact on your business. You want to kind of just take stock of where you are at and where you sit, in addition to understanding where your supplier sits and what their situation is. And then we also encourage you to begin to explore the option of an alternative supplier. And the first step being just understanding what your rights are, reviewing your underlying agreements, purchase order, long-term contracts, and see to what extent you have the right or option to either terminate those agreements or simply seek supplies from other vendors and suppliers. And you want to take note of any exclusivity type provisions or requirement type contracts that would prohibit you from seeking goods and services from other third-party vendors. Next slide, please. So once you've evaluated your rights and your ability to seek suppliers, alternative suppliers, you then want to kind of begin to seek and identify other suppliers and begin the process of integrating them into your operations. So again, identify alternative sources, see to what extent that they can begin to supply you goods, maybe commence a dual sourcing type situation where you continue to get the majority of your goods from your distressed supplier, but slowly are acquiring more and more goods and inventory and raw materials from an alternative supplier and slowly integrating that into your supply chain, so that if things continue to deteriorate for your distressed supplier, that you do have an alternative source that you can turn to, so it's not as disruptive for your own business. You do want to keep in mind, in addition to your rights, to seek an alternate supplier, seek out, and you understand the feasibility of that, understand if your current distressed supplier has certain intellectual property rights or certain processes that are essential to your production that would make it either difficult or impossible for you to seek an alternative supplier, even if you have the legal right to do so. You want to identify how quickly the alternative source can supply you and whether they can meet your demands. Identify any incremental costs associated with the alternative supplier. Those costs may be a source of potential claim should your original distressed supplier end up in bankruptcy. Next slide, please. Now, if your supplier does find themselves eventually in bankruptcy, in addition to some of the other things that John mentioned in terms of deadlines and kind of understanding what the supplier situation is with their existing lenders and things of that nature. In the supplier case, you want to take note of any accommodation agreements that may be in existence, and understand what those agreements are and what the terms are, and explore either entering into those or simply negotiating your own agreement. Again, you want to keep tabs of any incremental costs that you incur in connection with the disruption to your supply chain, and consider whether those costs may serve as a basis for a claim against the bankrupt supplier. Next slide, please. With regards to payables, we would encourage people to freeze paying on payables. Again, just to evaluate the situation of your supplier, to maintain a source of leverage, negotiating accommodation agreements or negotiating your business relationship moving forward. And then finally, you may also be able to take advantage of certain recoupment or offset rights. And so you want to keep that card in your hand as part of the process moving forward with that particular supplier. Next slide, please. And then you finally want to assess the impact on your business, and so you want to understand how disruptive this is going to be on your business based on the size or how critical the supplier is to your business. Determine whether it's necessary to have someone on site, determine whether it's necessary to have an access agreement of some sort, and determine to what degree you want to try to continue to make the business relationship work, depending on how critical that supplier is and depending on how much you value that business relationship. Again, these are all things that absolutely require communication between you and your supplier. Without communication, this is not necessarily impossible, but very difficult to achieve. Next slide, please. And then that's really it as far as what we advise for the rest of the supplier. Now, we did want to provide some practical pieces of advice, just navigating the situation both with suppliers and customers. The first piece of advice being that we really want to encourage that you do your own diligence, particularly depending on the community that you're in. Oftentimes, you'll hear false rumors, financial distress, things that may or may not be true, things that you may see in the media or press coverage, or things that you hear about the industry generally. Again, coming back to the community.
Sorry, I don't want to interrupt here, Loic, but I think one of the important points here is that if you do hear rumors or see press coverage, you want to try to confirm that with the best information possible. And often that is if it's a bankruptcy filing. Bankruptcy attorneys have access to public records that can give you significantly more details about whether a bankruptcy was filed, the date the bankruptcy was filed, the deadlines that have been set in the bankruptcy, and give you a lot more information about your options going forward. So if you see that a customer or a supplier or believe that they may have filed bankruptcy, or they're telling you that they filed bankruptcy, you want to confirm that before you take any further action. And the best way to do that is to talk to a bankruptcy attorney who has access to the records and can confirm one way or the other what the status is.
Thank you, John. Next point here is just take note of unusual behavior. Just some examples here. If you have a particular customer that makes an unusually large order, they may be building up their inventory and doing what they can to get through what they anticipate to be a financially difficult position for them. So anything like that would be unusual. Changes in payment terms or payment methods. Changes in management, senior management, hiring of restructuring advisors, or the appointment of a chief restructuring officer, and then changes in the client relationship, just people not picking up their phones or people not calling you back, just changes in the dynamic in a negative way that you notice are all red flags and all signs that you should take note of. John, I don't know if you had anything else to add on any other unusual behavioral changes.
No, not on that one.
We spoke about executory contracts and how to manage those. You want to avoid long-term contracts and avoid customer concentration issues with distressed customers. And so to the extent you can operate on a month-to-month or PO basis, that gives you an advantage should you be working with a distressed customer or vendor. You want to
I guess, Loic, at this point, the one piece of advice I would add to this is if you feel that a customer is experiencing financial difficulties and you're seeing signs of it and you're afraid there might be a bankruptcy coming up, you want to obviously reduce any receivable as far as a customer is concerned to the lowest point possible and zero if possible. If you can take actions to do that, I recommend that you take actions to do that, even if those actions may later come back to result in some type of preference claim against you or something like that, because the advantages of getting that receivable down significantly outweigh the disadvantages of having to defend a preference action. And the cost is typically less to get out from under a preference action, especially if it's a big receivable, than the benefit you get from collecting all or most of that receivable.
Thank you, John. Just on to our next point here, I'm stressing the importance of getting in contact with counsel. If any customer or vendor files for bankruptcy, understanding how to navigate that arena and making sure that you don't overstep in any way that may result in any penalty or fine. Be creative. You want to understand what your constituents are going through and trying to figure out in a creative way how to manage that situation. To the extent you can be collaborative and creative, that oftentimes saves a lot of time, hassle, and expense. John, I don't know if you have anything else to add on any of those points.
I do not. I think that pretty much covers the waterfront. Okay, so we have another slide here. Okay, modifying billing practices. Again, as I mentioned before, accelerate billings, follow up regularly. The lower you can get that receivable, the better. And considering alternative dispute resolutions makes some sense, especially if the relationship has deteriorated significantly. But again, communication. I think that is probably the most important takeaway from this session that you can have. If you identify someone who you think is experiencing problems, talk to them and see if they'll talk to you, because the more information you can get, the better. Loic, anything else?
Thank you. Yeah, thank you, John. I think next slide. I think that's all that we have. Again, we want to strongly encourage everyone to reach out to us if you have any questions. We're happy to further discuss or further explain anything that you may have heard in this webinar or anything that you're currently experiencing. John,
thank
do you want to have any final
I just want to say thank everyone for coming, and I hope everyone has a good day. And again, if you have any questions about any suppliers or customers or anything else related to creditors' rights or bankruptcy, please feel free to reach out to Loic or myself. Thanks for coming.
Thank you. Final remarks is, and we won't really go over this now, but at the end of the slides here that will be made publicly available, you will find information about our Back to Work Resource Center, which is a resource for people to just a conglomeration of documents and advisory pieces and resources that we provide for people managing getting their people back to work and how to do so in a safe manner in compliance with law. And you'll also find information about our PPP audit preparedness program for those that have taken out PPP loans. The prospect of being audited is very real, depending on the size of the loan, and we also offer services on advising people on how to prepare for those audits and how to maximize your defenses against those audits. So take a look at those and feel free to reach out if there are any questions. Thank you, and have a wonderful rest of the day and wonderful rest of the week.